Hello and welcome to our webinar on family arbitration, which is going to give you an introduction to everything you really need to know in order to successfully run a family arbitration, prepare your client for it and prepare your case for it, and know exactly what to do when you get there. I'm going to very briefly just introduce you to the topics we're going to cover and also to the speakers. I'm Andrzej, Bojarski, the head of 36 Family. I'm an arbitrator, also a mediator in both the family and the civil models. The first voice you'll hear after me, dealing with the first part of the talk, is Rhys Taylor, who is also a barrister, member of 36 Bedford Row, also a arbitrator under the IFLA scheme, and also a collaborative lawyer. Rhys is well known for his advocacy of the benefits of family arbitration, having been one of the founders of the Family Arbitrator website, and for his efforts in that endeavour, he was awarded the prize of most innovative family lawyer together with his co-collaborators on that website in 2012 by Jordan's Family Law. After Rhys, you will hear from Paul Infield talking about the IFLA scheme. Paul is also a qualified arbitrator, also a mediator with experience in financial cases and broader cases beyond that, also a barrister here at 36 Bedford Row. And I, as I've already said, will be finishing the presentation. Just to give you a brief outline of what the topics that we're going to be covering today are, we're going to start with a broad introduction to the principles of arbitration, where Rhys will take you through the main provisions of the Arbitration Act 1996, which is the governing legislation for arbitration in the generic sense. We'll then hear from Paul, who will take you through the IFLA scheme specifically and the family arbitration scheme with a walk through the procedure that's applied to family arbitrations. Then Rhys will take you through the provisions that interact from the Arbitration Act that provides support from the court for the arbitration process in the family scheme, and then also the supervision by the court in the family arbitration scheme. Finally, I will then deal with topic 5 there, the relationship between the IFLA arbitration scheme and the family court and the civil courts more generally. And I'll also then touch on the reforms of the future as to how the law is going to develop to better accommodate the IFLA arbitration scheme within the family rules more generally. So I'll hand straight over to Rhys.
Thank you, Andrzej. As Andrzej said a moment ago, I'm going to just speak a little bit about provisions in the Arbitration Act. The Arbitration Act 1996 codifies best arbitration practice at the time that the legislation was passed and also consolidated some previous arbitration acts. Arbitration is generally considered to work very well in the commercial context. Can it be translated into the family context? That's what we'd like to talk to you about this afternoon. In our general practices, there are statutory provisions which we go back to over and over again. Think of Section 25 of the Matrimonial Causes Act, or Section 1 of the Children Act, or overriding objective provisions in the procedural rules. And what I'd like to do is to briefly sketch out some of those foundational provisions of the Arbitration Act so that you can orientate yourself with legislation that perhaps a family lawyer is unfamiliar with. Starting at the start then with Section 1 of the Act. Section 1 operates like an overriding objective provision. It provides that the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. No problem with that then. The parties, secondly, should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. Again, nothing that frightens the horses there. But then in Section 1, subsection C, the court should not intervene except as provided by Part 1 of the Act. Now, the family lawyers amongst you might be starting to twitch a bit now and thinking, well, hang on a minute, how do you oust the jurisdiction of the court, the family court, under the Matrimonial Causes Act? And that's something that we'll touch on in due course. So Section 1 is your overriding foundational provision. There is then a duty on the arbitrator to be found in Section 33. And the duty of the arbitrator is to act impartially as between the parties, giving each a reasonable opportunity of putting his case and dealing with that of his opponent. And the arbitrator is to adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expense, so as to provide a fair means for the resolution of matters falling to be determined. And in all decisions which are made, the tribunal should comply with this general duty. The third part of the triumvirate that makes up the foundational principles is to be found in section 40 of the Act, and that puts a general duty on the parties, and they must do all things necessary for the proper and expeditious conduct of arbitral proceedings, and they must comply without delay with any determination of the tribunal as to procedural or evidential matters, or with any other order or directions of the tribunal. So one can triangulate the Act around those three provisions: an overriding objective provision and a duty on both the arbitrator and the parties to further that cause. There are two further foundational provisions which need to be introduced. Section 3 of the Arbitration Act provides for the seat of the arbitration. What's that? Well, in the commercial context, it allows parties to choose the substantive law of the arbitration. As Paul will explain in a moment, it's a fundamental rule of the IFLA scheme that the dispute will be conducted in accordance with the law of England and Wales. So Section 3 doesn't have huge relevance in the IFLA context. And then you have Section 4 of the Act, which cross-refers to Schedule 1 of the Act, which lists the mandatory and the non-mandatory provisions of the Act. Wouldn't it be lovely if all acts had those bits which you could simply disapply if you didn't wish to have to work with them? But the idea of arbitration is that it's flexible and that what works in one context might not work in another context. So there are, as it were, a set of default rules which will apply in the Act unless the parties choose to apply them in a different way. And that is perfectly permissible for the non-mandatory provisions. As we go through the talk, you'll see that some of the provisions of the Arbitration Act 1996 are mandatory and cannot be contracted out of. I'll now hand over to Paul, who will explain a little bit about the IFLA rules and how they relate to the Act.
The Arbitration Act is a framework, a quite complicated framework, but if you look at it, you'll see that it gives a number of choices as to how one applies the rules that are set out in it. And what IFLA has done with the rules, the most recent iteration of which was produced in February of 2014, what those rules do is in effect to make most, if not all, of the choices for you. So, for instance, as Rhys said, the seat of the arbitration has to be England and Wales. There is no choice about that. The law you apply is the law of England and Wales. That doesn't mean, of course, that you can't actually hold your IFLA-based arbitration anywhere in the world. We've known of arbitrations that have taken place in places like Dubai, for instance, but the law that's applied, the seat of the arbitration, is still England and Wales. You start off an arbitration under the IFLA scheme with a form, inevitably with an acronym, this being family law, called ARB1. That's ARB1. And the ARB1, which is worth having a look at, is actually a remarkably, given the family context, and at least in comparison with Form E, a remarkably simple document. You have to set out things like your client's name and contact details and so on. We'll be coming in a minute to some of the choices you have to make on the ARB1, but it is, as you'll see if you have it in front of you, a relatively short and simple document. And what I want to turn to now is the IFLA rules, which are form the basis upon which you start an arbitration with form ARB1. First of all, Article 2. Article 2 sets out the scope of disputes that can be litigated under the IFLA rules. And the scope is quite wide. It includes not just disputes under the Matrimonial Causes Act 1973, but under TOLATA, that's the Trust of Land and Appointment of Trustees Act 1996, Schedule 1 claims, civil partnership disputes, disputes under Section 12 of the Matrimonial and Family Proceedings Act 1984, that's financial relief after an overseas divorce, disputes under the Married Women's Property Act 1882, and under the Inheritance Provision for Family Independence Act 1975. And what it doesn't cover, and these are at the moment important exclusions, are anything to do with the care and parenting of children, anything to do with the status of individuals or their relationships, bankruptcy or insolvency, though of course bankruptcy or insolvency may affect disputes under the MCA and TOLATA and so on, anything to do with liberty of individuals, and any disputes that involve third parties, unless of course those third parties are parties to the arbitration. Article 3 provides for the applicable law, and as I've already said, the applicable law under the IFLA scheme has to be the law of England and Wales. That doesn't mean, though, that evidence of the law of another country can't be admitted. It can, but only in the same way as a judge of the High Court could admit such evidence. Articles 4 and 5 deal with how you appoint the arbitrator. The parties choose the arbitrator, and that's one of the things that you'll see on the ARB1. You can actually choose who your arbitrator is. But if you can't agree on the identity of the arbitrator, you can ask the Institute of Family Law Arbitrators, IFLA, to choose one for you. And that may be what most people do, given the difficulties that often arise, for instance, in choosing mediators. Even that's likely to be even greater when choosing an arbitrator. Each of the parties must complete and sign the form ARB1, and the arbitration commences upon the arbitrator having agreed the terms. It's right to note here that many arbitrators, certainly family law arbitrators, will offer no strings pre-appointment meetings, so you can get to meet them and decide, both parties can decide whether they're the appropriate arbitrator to decide on the dispute. Article 6 deals with communication, and the important rule here is that there must be no unilateral communication with the arbitrator. So, for instance, email is an ideal form of communication because that can be copied to the other party. But neither party can approach the arbitrator or communicate with the arbitrator alone, and anything that is communicated in that way should be at once communicated to the other party. Article 7 deals with powers. The arbitrator has the power to make orders or awards, either interim or final, to the same extent and in the same or similar form as would a High Court judge. But the arbitrator doesn't have power to make interim injunctions, commit someone, nor does he have jurisdiction over non-parties, as I said earlier, without their agreement. If the arbitrator considers that the dispute is not suitable for arbitration under the scheme, he has the power to terminate the proceedings. And that's doubtless something you would discuss if you did have a pre-appointment meeting. But even if you didn't at that stage, the arbitrator can later decide to terminate the arbitration if he doesn't think by that stage, that it is appropriate for arbitration. Article 9 provides that the parties are free to agree a form of procedure, if necessary, with the concurrence of the arbitrator, including, for instance, a documents-only procedure, and that's increasingly common. If there is no agreement, the arbitrator has the widest possible discretion in relation to procedure. In practice, arbitrations, both in the commercial context and in the family context, are rather more informal than court procedure, even court procedure before district judges. But it's ultimately up to the individual arbitrator or the parties to decide on the format. Article 10 deals with general procedure, and in effect, at this stage, it's right to note that there are two alternative procedures. The first, under Article 10, is what one might call the general procedure. That's a procedure that's rather like the sort of civil procedure that those who practice under the civil procedural rules will be familiar with. So that might be appropriate, for instance, for Tolata disputes or perhaps for Inheritance Act disputes. But one could use it for other disputes as well. Article 12 provides for an alternative procedure, which is much more akin to the sort of financial remedy procedure, which those of us who practice under the family procedure rules in financial relief cases will be very familiar with. But that, again, are matters that can and should be discussed with the arbitrator at an early stage. So, for instance, under Article 10, you'll have things like pleadings and disclosure and witness statements, limiting experts and so on, whereas Article 12 has the more familiar financial relief procedure. Article 13, I'm sorry, perhaps I should just go back to Article 8 in this context. Article 8 provides that the arbitrator's decision on procedure is final, but the parties can propose a procedure prior to his appointment, and if the arbitrator thinks that's not appropriate, he or she can decline jurisdiction. The parties can, of course, also propose a procedure after the appointment, but again, subject to the arbitrator's agreement. So let me turn then to Article 13. That provides that the award must be delivered within a reasonable time in writing. It must be signed, dated, and state the seat of the arbitration. But a question that I'm often asked at this, when we're talking about arbitration, is it binding? It's an important question, and it's one that's really held up this sort of arbitration in financial matrimonial cases for some time, because, as Rhys touched on, you can't oust the jurisdiction of the court. Well, the answer is that if the parties are married, the award itself is not binding. However, it appears now the courts will enforce it in general terms, because if someone opposes the enforcement of an arbitration award, they have to use the show cause procedure as set out in the recent case of S&S, in which the President made it clear that it was only in extreme cases that an award would not be enforced. For unmarried couples, for instance in Tolata cases, it appears to us that the award is enforceable without more, just as an agreement between parties in such disputes would be enforceable simply contractually. But that's something that Rhys will deal with later. The only reason that an award is unlikely to be enforced is if the arbitrator lacked jurisdiction. Well, that's unlikely to arrive in an arbitration under the IFLA scheme, or if there's a serious irregularity, to use the language of the Act, causing substantial injustice, or by agreement, or with the court's leave, an appeal on a point of law, unless that's been expressly excluded by the parties. Article 14 deals with costs. And the starting position is, as in the courts, no order as to costs, unless otherwise agreed, though of course that again is subject to the arbitrator's discretion to depart from that if appropriate. Now I just want to deal briefly with the benefits and the disadvantages of family arbitration. Well, obviously the benefits of a family arbitration are the speed of the process. We all know of the delays that are currently affecting the court system. You can wait months to get your first appointment, months again to get your FDR, and then even longer to get a final hearing, date for a final hearing, particularly if it's going to be over several days. With an arbitration, you effectively choose your own timetable, and subject to the availability of all the parties and the arbitrator, you can get your arbitration on very quickly. You can, for instance, do without an FDR entirely. You can do your hearings, conduct your hearings over the phone or over Skype. So there's a flexibility and a control over the procedure, which we've already touched on. But speed is one of the major advantages of arbitration. Another major advantage is complete confidentiality, particularly important for some people, and particularly nowadays when openness seems to me increasingly important for the family court system. There is, of course, a choice of arbitrator, a continuity of your judge, because your arbitrator is the same throughout, and their availability. And of course, you can select the issues to be arbitrated. You don't have to arbitrate the whole of a dispute. You can arbitrate simply one or two or more issues in an otherwise court-based or other-based process. So, for instance, you can be mediating, have a dispute over one or more issues, arbitrate that, and then go back and continue with the mediation. There are, though, some disadvantages, and you're going to touch on those, Rhys, I think.
Yes, well, thank you, Paul. We've all been in court, haven't we, when the district judge has simply got too much in his list and he either doesn't get to you or he doesn't have enough time to finish your case. I think we've all got stories of when we've been at court embarrassed with the court facilities which have been afforded to us, simply being unable to privately consult with our clients. Some of us, and I mean no disrespect in saying this, have had experience of attending before a deputy district judge who very clearly has very little feel for financial remedy work, it not being his or her area of practice. And when we give this lecture to people in live seminars, we tend to take a show of hands as to who, since the coming into force of the family court, has had the experience of a judge simply not turning up at all. And I'm certainly one of the people who puts his hand up, and there are a number of other people who have shared similar stories with me. And of course, all of these things don't happen in arbitration. But as Paul rightly says, there are some disadvantages. The first is you're not paying for either 2 or 4 lawyers. There's the extra lawyer, the arbitrator, to pay for. It's sometimes thought that the speed with which you'll be able to get through your proceedings is enough to outweigh that cost, but undoubtedly it's there. There's also a very limited right of challenge or appeal to arbitral awards. It's my understanding that last year there was something in the order of about 3,000 commercial arbitrations conducted in London, and the number of successful appeals which are made to those decisions you could count on 2 hands. And if you don't want a quick decision and you want the opportunity to continue appealing and the like, then arbitration is not for you. And then, of course, an arbitration isn't an enforceable decision. It's one which needs to be implemented by the court. And there's that extra step that needs to be taken in the proceedings, which Andrzej will explain in a moment as to how the case of S&S works and what you need to do to implement your order. In some circumstances, people might be uncomfortable with that. But there you are. It's a voluntary process. There are a lot of benefits. And if you go into it with your eyes open, perhaps the disadvantages, when coolly analysed, are not as bad as they might otherwise seem. I'd like to turn then to the relationship between arbitration and the civil court. I'm going to talk essentially about the Talata context, or the general common law context. And then when Andrzej speaks in a moment, he's going to deal with how things work in the family context, with the extra considerations which are at play in that context. The first point, already touched upon by Paul, is that the arbitrator has absolutely no independent coercive powers. He's not a judge. He's simply appointed to arbitrate the dispute as between the parties, and looks to the court for support, which I'll come to in a moment. And as I indicated at the outset, Section 1 of the Act provides that in matters provided by this part, the court shall not intervene except as provided by Part 1 of the Act. So what does Part 1 of the Act deal with? Well, first of all, it deals with stays. And why are stays necessary? Well, you may have the situation where a case starts well before an arbitrator, but then one of the parties gets cold feet. He might actually not like the disclosure order that's been made, or some direction which he really doesn't want to comply with. And rather than cooperating and complying with his duties under Section 40 of the Act, he may actually decide to go and issue proceedings down at the local court in competition with the arbitration. And what is the Arbitration Act's response to that? Well, in the civil context, the Section 9 of the Act provides for a mandatory stay of court proceedings which have been commenced in defiance of an arbitration agreement. CPR 6232 provides that the application shall be made to the court in which legal proceedings have been commenced. You need to bear in mind that you mustn't engage properly with the civil proceedings in court at all. You must simply acknowledge the legal proceedings, don't file a defence, and immediately put in an application for it to be stayed. And the outcome will be a mandatory stay. Another way in which the court supports an arbitration is by the way in which what is known as peremptory orders are complied with. What happens if the parties simply won't comply with their Section 40 duty? Well, under Section 41, the arbitrator, has the power to make a peremptory order, which is essentially an order saying that, look, I've made some directions already, and I'm now really expecting you to comply with these directions. And if you don't, there may be consequences, and those consequences can be set out. If a party fails to comply with that peremptory order, it is open to the arbitrator to direct that a party cannot rely on a particular allegation. The arbitrator may draw adverse inferences from non-compliance, or may proceed to make an award on the material available, or make an order for costs. But there's also Section 42 of the Act, which provides an arbitrator, but more likely a party with the arbitrator's permission, may apply to court to enforce a peremptory order of the arbitrator. Before this step is taken, all attempts must be made to secure compliance in the arbitration context. And then the court may make an order requiring to comply with a peremptory order, and the usual court sanctions can be deployed if that is ignored. We sometimes talk about negotiations to settle ancillary relief proceedings taking place in the shadow of the law. Perhaps a case might not see the inside of a courtroom, but nonetheless the parties organise their affairs and conduct their negotiations in the knowledge as to what is likely to happen in the event that they're unable to come to an agreement. And I'd suggest that the way in which arbitration works is essentially in the shadow of the law. If the parties don't comply with directions, they know that there will be consequences, and ultimately there may be penal consequences coming from the court for failing to comply. An application for a peremptory order is different in nature to an application for a stay. It's defined in the rules as a Arbitration Act claim and must be brought following the procedure set out in Part 62 of the Civil Procedure Rules. Presently, that must be commenced in the High Court, either in the Admiralty, Commercial, Technology and Construction or Mercantile Court, or as Andrzej will explain in a moment, there are plans afoot to allow those applications to be made directly into the family court. In any event, an issue of that application would be immediately transferred to the family court. Think of it akin to a bankruptcy situation where the family court can exercise a pure bankruptcy jurisdiction alongside a family jurisdiction, but the bankruptcy proceedings can't be commenced in the family court. They have to be commenced elsewhere and then transferred in. And that's done by way of Part 8 procedure with supporting evidence, and it's heard in private unless otherwise ordered. There's also provision to summon witnesses to an arbitration. Both the witnesses and the arbitration need to be in England and Wales, and parties can only be compelled to produce documents which would be available in legal proceedings. The court can also make injunctions and other coercive orders in support of the arbitration. It's possible for a court to decide a question of law in very limited circumstances. I'd suggest that if there's a genuinely novel point of law in play in financial remedy proceedings, it's unlikely that the parties would wish to use arbitration and to use this provision. But there is still the opportunity, if the parties so wish, sometimes used in the commercial context, for the parties to commence arbitration, refer their legal point to the court, have the court decide the legal point, and then pass the answer back to the arbitrator. But that must be with agreement of both of the parties or with permission of the arbitrator, and the court has to be satisfied that the determination is likely to produce substantial savings in costs and that the application has been made without delay. It's also necessary, as it says at the top of the slide, that it must substantially affect the rights of one or more of the parties in the case. It's a very rare provision. So that's a quick introduction to the support by the court. Very briefly then, looking at supervision by the court. What do you do if something goes wrong? Well, there's a number of ways in which the parties and indeed the arbitrator can be brought to heel by the court if something goes wrong. In the first instance, there's a challenge to an award based on a decision being made that lacked substantive jurisdiction. The short point is, if you are invited in an ARB 1 decision to determine the beneficial ownership of Whiteacre, and in your award a decision is made which deals with both the beneficial ownership of Whiteacre and Blackacre, the arbitrator has exceeded his or her jurisdiction because he was never asked to deal with Blackacre in the first instance. And Section 67 is a mandatory provision, cannot be excluded by the parties' agreement. This provision, in order for it to apply, the party must raise and exhaust any challenge within the arbitration in the first instance. It's no good just sitting on the point and waiting till the end of the case. And the right to challenge may also be lost by delay. The court, when dealing with one of these applications, can confirm, vary or set aside in whole or part the award, or to declare that the award is of no effect due to lack of substantive jurisdiction. But as I've already indicated, successful challenges in the commercial context are exceedingly rare. You then have the serious irregularity challenge, and that's basically an opportunity for the parties to challenge the award on the basis that the arbitrator really just has made a complete and utter horlicks of the situation. But it's not a challenge to the factual determinations made by the arbitrator. A number of decisions make it clear that the provision is to deal with an arbitrator's failure procedurally to deal with the proceedings properly. So a failure to comply with Section 33, exceeding powers, failing to conduct the proceedings in accordance with the procedure agreed by the parties. They're all procedural issues, and it's not, says the High Court in a number of decisions, an opportunity for the parties to seek to challenge factual findings which have been made by an arbitrator. You also have an appeal on a point of law under Section 69. That appeal must be made within 28 days, but that is a non-mandatory provision and can be excluded by the parties by agreement. All remedies before an arbitrator must have been exhausted before that step is taken, including inviting the arbitrator to correct his or her award first. So far as enforcement is concerned, that is done under Section 66 of the Arbitration Act, and essentially the party with the benefit of an award can invite the court to implement it in the same effect as the award has been drafted, and an award, certainly under the IFLA scheme, under many other schemes as well, will contain a decision, reasons, and a draft order. And of course, the arbitrator will have very firmly in mind the jurisdiction that the court has and the orders that the court can and can't make, and will allow that to be easily converted into a court order.
What Rhys has just taken you through in terms of the civil jurisdiction and the Arbitration Act is a fairly well-trodden road now, and a well rehearsed path, because as he mentioned, 2,000 or 3,000 civil arbitrations take place in London every year, and the rules accommodate those, and the law has developed very well. The IFLA scheme is of course new. It was only created in April 2012, and at the time of us speaking now in December 2014, the number of arbitrations that have taken place are in the mid-30s. So it's still developing, and unfortunately the rules to date have not yet been brought fully up to date, but that is something which, as I'll explain in due course, is being looked at. There are clearly contrasts, as has already been pointed out by both Paul and Rhys in their earlier comments, between the civil commercial model and some of the family areas that family law arbitration covers, and the question of direct enforceability, particularly when dealing with those provisions where the court retains overall jurisdiction to deal with the fairness of an award, and that jurisdiction cannot be ousted, raises particular difficulties. So how does family arbitration relate to the court in family proceedings? And we have to distinguish here the way it deals with each types of proceedings. The scheme, as Paul told you, covers a variety of different types of case, and the way it will interact with the court will be different in each particular case. Perhaps most of the cases that have taken place so far have been in the matrimonial or the civil partnership context, so financial remedy proceedings. Those, as you know, are proceedings where the jurisdiction of the court cannot be ousted, and until there is a final order of the court, there will need to be any award that the arbitrator makes is some perhaps uncertain status, but I'll explain in due course how the case law has given us confidence that the arbitrator's award will be decisive in most cases where there's been an arbitration, and effectively will be as good as a final agreement or a order of the court. Schedule 1 applications raise very similar issues because, of course, the court has to consider the criteria within Schedule 1 before making provision, and again, it's a jurisdiction that cannot be ousted. So the principles will apply much the same way there as they do to matrimonial causes. Inheritance provision for Family Independence Act claims is perhaps slightly different, because here you're dealing partly with rights of litigants between each other, and you're also potentially dealing with matters that bind the world and may also affect tax affairs and so forth. And so there may be a distinction between those matters which are dealt with within an arbitration which don't require any further sanction of the court to be binding and which can be directly enforced under the Arbitration Act, and those which will require some order of the court to ensure that it has the necessary fiscal effect. Perhaps the simplest and easiest to deal with are those cases which are pure civil proceedings as far as the law stands, so those cases that concern tolata and property claims, because those are cases which are full square within the principles that Rhys has just been talking about in the commercial and civil context, and those are cases where the Arbitration Act will apply directly without any need for a further order of the court other than enforcement of the award under the Arbitration Act. As I mentioned already, there have been relatively few at the time of speaking family arbitrations, and part of the reason for that is almost certainly that the scheme is new, and there's been a degree of scepticism and perhaps concern from the profession as to how legal these procedures are and how robust the process will be in terms of a binding award. Now, until recently, we had some encouraging noises from the judiciary through cases such as like Duplo there, where you can see the passage on the screen from Thorpe LJ making very positive comments about private judging in the arbitration scheme. AI and MT, although not strictly speaking a family arbitration case, a case where parties had agreed to refer a dispute over their children to a Bedford court in New York, again, broadly speaking, encouraging noises about parties having the right to make decisions through a course of dispute resolution other than the courts, and the court providing support for that process. And then in W&M, a tolata case before Mr. Justice Mostyn, where he endorsed the benefits of arbitration for parties who wish to have the benefits of confidentiality in what would otherwise be civil proceedings dealt with in open court, where it concerned a tolata case. Now, those were encouraging words, but of course not by themselves binding, until the decision of Sir James Munby, the President, earlier in 2014, where he endorsed a award that had been made by an arbitrator and made an order in those terms, and in the course of his judgment doing so, gave some very positive endorsements of the IFLA scheme, endorsements which, certainly in our view, should dispel any concerns that previously existed as to the validity and the binding nature of the process that's taking place. Now, it's of course worth saying that this is a decision where an award which had been made by the arbitrator was being presented to the court for approval and to be turned into an order of the court. So there was no argument here as to the validity of the scheme, and strictly speaking, the President's comments are all obiter comments. But nevertheless, it would be very surprising if this were not to be taken as a reliable and definitive statement of what the law on the area now is. You'll see a number of extracts from the judgment on the screen. The President made it clear that an agreement to arbitrate under the IFLA scheme is likely to be considered a single magnetic factor of determinative importance in any case. So it'll be deemed to be of similar weight to an agreement, a settlement agreement or a prenuptial agreement, which isn't undermined in any other way, and one which is likely to be the decisive feature in the court's determination of the case. And to strengthen that, he went on to say that in the absence of some very compelling countervailing factors, the arbitral award should be determinative of the order of the court. He then went on to say that there is no conceptual difference between the parties making an agreement and agreeing to give an arbitrator the power to make the decision for them. And he then went on to say that an arbitral award was of its nature even stronger than a simple agreement between the parties, because, of course, rather than simply the parties agreeing between themselves what they thought was fair, here is a decision being brought by an experienced practitioner in the field who's been appointed as an arbitrator, who's looked at all of the material and then written a reasoned decision as to what would be a fair outcome of the case. The President went on to say that where the consent order which the judge was being asked to approve was founded on an arbitral award under the IFLA scheme, the judge will not need to play the detective unless something leapt off the page to indicate that something had gone so seriously wrong in the arbitral process as fundamentally to vitiate the arbitral award, and it could only be in the rarest of cases that it would be appropriate for the judge to do other than approve the order. So the President was endorsing what would effectively be a summary procedure in these cases, where effectively the judge would do little more than read the award, and then if there were no strong factors to suggest the award was unfair, endorse it by making an order in the same terms as those proposed by the arbitrator. The President also said the parties should lodge with the court both the agreed submission to arbitration, in other words the ARB1 form that Paul told you about, and the arbitrator's award. The order that's submitted with it, this is in the case of a consent order being submitted to the court, should contain recitals setting out the documents which have been lodged with the court and stating that the parties had agreed to arbitration and that they now sought approval by the court. And those of you that have used the standard forms of orders now produced for use in these proceedings will see that there are those specimen clauses included within the draft ready for your use. So that deals with the process that the courts will deal with where the parties have been to arbitration and then present the award to the court. But what happens if one of the parties decides to be a little bit more difficult about it? Well, the first question that arises is what happens if one has an award that's been made under the provisions of the arbitration scheme and then proceedings are issued. Does Section 9 of the Arbitration Act, which you'll remember is the provision that requires the court to stay proceedings brought outside the arbitration to allow the arbitration to proceed, does that provision apply and override Section 34 of the Matrimonial Causes Act, which gives the court an unoustable jurisdiction to deal with applications for financial provision? Well, the question hasn't been directly decided by the courts. It was sought to be argued in T&T Humane Injunction, although Nicholas Francis QC, who dealt with the matter, decided it wasn't necessary to decide that question for the purposes of his judgment in that case, and so didn't do so, but nevertheless made some probably encouraging comments in favour of Section 9 applying. And the authors of Todd's relationship agreements certainly suggest that where you include an arbitration clause within a prenuptial agreement, the court ought to and can use Section 9 of the Arbitration Act to stay the Matrimonial Causes Act proceedings until the matter has been referred to arbitration. The Law Commission touched on the question within its recent report on matrimonial property needs and sharing, and it also noted that the law hasn't yet been decisively or authoritatively resolved, but certainly leaves it open. And there may be some useful guidance from this case of AES Ust-Kamenogorsk and Ust-Kamenogorsk JSC, which dealt with the question of how the courts deal with a conflict between different statutes, such as the Arbitration Act and, in this case, the Senior Courts Act or the Matrimonial Causes Act. And in that decision, the Supreme Court took the view that the interpretation of each act is informed by the other. So certainly that would suggest that if the same issue arose in this case between the Matrimonial Causes Act and the Arbitration Act, one would read the two acts together and the purpose of both acts to reach a appropriate resolution. In reality, those issues are probably not going to arise too directly in most cases, and the decision of Mr. Justice Mostyn in Man and Man earlier in 2014 is perhaps helpful. He there was dealing with an application to stay or adjourn proceedings so that the parties would go to mediation, as they had previously agreed in an earlier order that they would. And he said that, as he'd stated, if there's a written agreement to engage in ADR, which as I say in that case was mediation, before going ahead with a Part 8 or an enforcement application, then I consider that the rule may be invoked to adjourn the application for a specified period to enable ADR to take place, even if one party is trying to back out of the ADR agreement. I don't need to read the rest of it there particularly because it deals with the specifics of that case. However, given that the rules provide the court with a general power of staying proceedings, and indeed it can also adjourn proceedings to allow ADR to take place, what is likely to happen in our suggestion in a case where a party issues Matrimonial Causes Act application in the face of an already signed one and a referral to arbitration, is that the other party will ask the court to stay the court proceedings for a period of time. And if the court adjourns or stays those proceedings for a period of 4 or 5 or 6 months, the likelihood is that the arbitration will have continued and concluded in that period of time prior to the court process taking any further steps. So there is provision within the rules that probably means that Section 9 of the Arbitration Act doesn't need to be directly invoked in many cases. What do you do if you end up with a situation where you need to bring a matter before the courts to deal with the Arbitration Act powers? Well, the CPR Part 62 allocate proceedings to certain courts, as Rhys has already told you. And a stay, as I've already mentioned, can be brought under CPR Part 62 to the High Court. Orders for support or supervision by the court, which is the raft of orders that can be sought to back up an arbitrator's authority in the interlocutory stages of proceedings. Those applications must, as Rhys mentioned, be allocated in the first instance to the commercial TCC or mercantile list, or the Central London County Court mercantile list. And at the moment, it would require you to issue the proceedings there and then see them transferred before a family judge. Enforcement applications are relatively easy because those will be commenced in civil proceedings before any county court. So if you're dealing with Talata applications, enforcement of those will be very easy. Where you're dealing with Schedule 1 proceedings or Matrimonial Causes Act proceedings, the likelihood is that you'll use the SNS type procedure, which is to simply issue an application by way of a notice to show cause in the family court, and the court will adopt the President's approach of a fairly summary assessment of the arbitrator's award, and unless very good reason is shown as to why that shouldn't be turned into an order of the court will endorse that. As yet, we're not aware of any cases where CPR Part 62 has had to be invoked in any of the family arbitrations which have taken place, which we would suggest that actually the process works generally very well, and at the moment suggests that these problems don't arise commonly. Our advice at the moment, at least until the rules are changed in ways that I'm going to touch on in just a moment, is, as has already been suggested, to issue any application in accordance with CPR Part 62 in the relevant civil court, and then immediately seek a transfer of the matter to the family division. And it may also be that the court will agree that that should be referred to a district judge of the Central Family Court, all of whom are also DJs of the High Court by nature of their appointment, and that would then allow the matter to proceed there. And you can see that the 1996 High Court and County Courts allocation of arbitration proceedings order does appear to allow a transfer between divisions of the High Court, despite the fact that the application in the first instance has to be brought to one of those who are allocated for Arbitration Act matters. As I say, all of that's the position at the moment, and the law in terms of the procedural rules have been a little bit slow in catching up with this development of family arbitration under the IFLA scheme. The President has made it very clear, as he already did through SNS, but also through his writings in his views from the President's chambers, that this is something which he wants to see addressed fairly quickly by the Family Court Rules Committee, and as I understand it, they are looking at the matter at the moment, with a view to making the process much smoother and allowing the applications that are currently reserved to the commercial court being brought in the family court. And to that extent, a number of proposals have been put by the Financial Remedies Working Group in Annex 12 to their recent report, suggesting various rules that ought to be changed and other amendments that need to be made to the procedure and the statutes to allow these matters to be dealt with in a purely family way, which is clearly what the IFLA scheme ideally would like to see happen. And those changes, as I say, we should see bearing fruit and coming into force in the not too distant future. Finally, just in case you want to find some further information out about family arbitration, there's a number of very useful resources which we've got on the screen there. The Family Arbitrator website, which I mentioned earlier on that Rhys was one of the founders of, contains a wealth of useful information, including a procedural summary that takes you through step by step the stages of an arbitration, various checklists that can be used by arbitrators and by parties in order to prepare themselves and to streamline the process of arbitration. There have been a number of writings by Sir Peter Singer, including 2 articles in Family Law, where he set out the procedures and issues that arise around arbitration. A very useful and user-friendly book by Dennis Sheridan, Family Law Arbitration, is available from the Law Society at a very reasonable price and provides a very useful handbook. And finally, Chapter 29 of my publication, Unlocking Matrimonial Assets on Divorce, also contains a chapter by Peter Singer, which provides a detailed analysis and commentary on how the IFLA scheme works. Thank you very much for your attention. You have at the very end of the slide contact details for each of the speakers. If you have any questions, we always welcome them, and we genuinely do, and we'll try and deal with them in order to assist you on your way into family arbitration, because it is a process we strongly endorse. Thank you.